Unlock critical insights into UK partnership law, a cornerstone for legal professionals, business owners, and students alike. This guide provides an authoritative overview of key statutory obligations and best practices. Understanding UK partnership liability is paramount for all stakeholders. Section 9 of the Partnership Act 1890 establishes joint and several liability, holding each partner both collectively and individually responsible for partnership debts. This means personal assets are at risk. Creditors can pursue any single partner for the full amount of a partnership debt. The paying partner then retains the right to seek contributions from co-partners. This principle underscores the significant personal financial exposure. Partners are also jointly and severally liable for wrongful acts or omissions committed by any partner within the ordinary course of business. This includes breaches of fiduciary duty or negligence, even if not directly involved. Robust case law consistently upholds this stringent liability. Mitigate these risks through comprehensive partnership agreements detailing internal contributions and indemnities. Professional indemnity insurance is also a vital safeguard, alongside thorough due diligence on prospective partners. Dissolution procedures are governed by the Partnership Act 1890, with additional requirements for LPs and LLPs. Dissolution can arise from agreement, notice, expiry of term, or events like a partner's death or bankruptcy. Key steps involve reviewing the partnership agreement for specific clauses and providing formal written notice to all partners and relevant third parties. All outstanding debts and liabilities must be settled before asset distribution. Remaining assets are then distributed according to the agreement or, in its absence, equally among partners. The partnership continues solely for the purpose of winding up its affairs, including completing unfinished transactions. For LLPs and LPs, final filings with Companies House and tax authorities are mandatory. Employing mediation for disputes and maintaining meticulous records are best practices during this complex process. A retiring partner must provide written notice as stipulated in the partnership agreement. Public notification, including Gazette publication, is crucial to protect the retiring partner from future liabilities. A formal deed of retirement details financial settlements and indemnity provisions. The retiring partner's share, encompassing capital, profits, and goodwill, is valued and paid out, often following asset revaluation. Expulsion is only permissible if explicitly provided for within the partnership agreement, outlining specific grounds and procedures. Procedural fairness dictates the partner must receive notice and an opportunity to respond. If no expulsion clause exists, unanimous consent or a court order is required. The expelled partner is entitled to the fair value of their share, necessitating a buyout. Partnership property encompasses all assets acquired for the business, held on trust for the partnership as a whole. While legal title may reside with one partner, all partners possess a beneficial interest proportionate to their share. Partners may only use partnership property for business purposes. They cannot transfer specific assets to third parties, only their share in the partnership as a whole is transferable. Upon dissolution, partnership property first settles debts. Any surplus is then distributed among partners according to their agreed shares. Clear definitions in the partnership agreement are essential. Recent changes under the Economic Crime and Corporate Transparency Act introduce new obligations for limited partnerships. LPs must now provide a standard industrial classification (SIC) code describing their main business activity. This mandatory disclosure applies at registration and in annual confirmation statements. All filings must be made through an authorized corporate service provider. LPs should identify their SIC code in anticipation of full implementation. Enhanced disclosure requirements aim to bolster transparency and combat illicit activities. LPs must maintain and disclose a register of persons with significant control, PSC, reporting changes promptly. Annual confirmation statements and, for some, financial reporting are now mandatory. Diligent AML compliance, including due diligence on partners and beneficial owners, is critical. The regulatory landscape for partnerships, particularly limited partnerships, is undergoing significant evolution. Proactive engagement with these changes is not merely advisable but imperative for compliance and risk mitigation. We urge all legal professionals, partners, accountants, business owners, and legal students to review their current partnership agreements and internal policies. Ensure alignment with the latest statutory requirements and best practices. Seek expert legal counsel to navigate these complexities and safeguard your interests effectively.